Okay, am I audible now?
Yes.
Okay, so now we will discuss the different types of rights that we have. First type that we have is right to equality. So which all articles are contained in right to equality?
15, ma'am.
Yeah, 14, 15 and
16, ma'am.
yeah, 16 also and 17, 18 also. So right to
Yes, ma'am. 14
equality,
to 18, ma'am.
yeah, 14 to 18. Now we will discuss different types of right to equality. First one that we have is equality before law. Now what equality before law says? It says the state shall not deny to any person equality before law and equal protection of the laws within the territory of India. That means under this article we have two different things. First is equality before law and second is equal protection of the laws. Now what does equality before law mean? Equality before law, what it means? Absence of privileges. For example, there is any particular law. For example, there is IPC, which has like defined and provided for various types of crimes. Now, if there is the Indian Penal Code that would be applicable for the criminal offences in India, there should be any absence of any sort of privileges. That particular law would be applicable to all the persons, irrespective of any privileges or any like special treatment given to the people. But there might be certain under that particular statute there might be certain exceptions given. For example, for any certain law the police cannot just come and arrest a person of certain designation, so there might be certain exceptions, but otherwise to the general public this law should be equally applicable. There should be absence of any privileges to any people under any law that is made applicable. Second is equal subjection of all the people to ordinary laws. Ordinary laws. So what this means? Equal subjection of the people to ordinary laws. If there is any particular law which is applicable to the whole of India, that particular law would be applicable to all the people who comes within that jurisdiction. If there is any state law, for example, there is Bombay Municipal Corporation Act. Okay, there is BMC Act. Now what happens is that this act would be applicable only to people within Bombay, right? So if there is any particular ordinary law, there should be equal subsection of all the people. All the people residing within Bombay would come under the jurisdiction of this particular act. So first one says absence of any special privilege or any special treatment. Second one says equal subjection of all the people. If one law is applicable to one section of the people, it should be applicable to other similar people as well. So for example, there are, restrictions on travel and movement of people because of COVID-19. Now that particular thing should be applicable to all the people. It's not like one person is allowed to travel without following the guidelines, without following the procedures, but others are not. So it should not be like that. Equal subjection of all the people. And thirdly, what it says is that no one is above law. That means everyone would come under the purview of law. Whatever is applicable to one person would be equally applicable to other persons in the same category as well. Second thing that we have is equal protection of the laws. Now what equal protection means? This is what? This is application of laws. One person is made answerable under any certain act. So those things should be equality before law. If one person is arrested under any particular act for commission of an offense, it should be equal for all. But equal protection would mean any sort of protections given to the people, any sort of special treatment given to the people. So it says equal treatment under equal circumstances, both in terms of privileges and liabilities. Equal treatment both for privileges and liabilities. Now, what equal treatment means? For example, there are certain special privileges given, right? That an offense committed by a child under 7 years is not considered as an offense. That particular privilege has to be given to any other child under the age of 7 years. It cannot be like one person is given, another one is not given. If there are certain liabilities given, for example, children between 7 to 12 years would be made liable under Juvenile Justice Act. Now what happens, this liability also would be similarly applicable. It cannot be like one person is made liable under juvenile justice, one person is made liable under IPC. So equal treatment basically means equal treatment should be given both in terms of any privilege or any sort of liabilities under any act to all the people under similar circumstances. Next is similar application of laws to people who are similarly situated. For example, under now during this time, okay, what happens is that like migrant workers and all the people who are living in daily wages, right? Government is providing some sort of financial assistance to those people. Now, if government is providing some sort of financial assistance or government is providing some benefits under any law or any statute, that has to be similarly given to all the people who are similarly situated. So it should be given to all the people who are similarly situated. If there is any sort of reservation given to the specially able people, right? It should be given to, that opportunity should be given to all the people who are similarly situated, because this is like a protection or like a facility given under the under that particular statute. And thirdly, like should be treated alike. Like should be treated alike. If there is any privilege, if there is any like liabilities, privilege, whatever it is, like should always be treated alike. If there is any act which is providing for for example, under constitution only, we are given a right that if a person is arrested, he has the right to at least make one phone call and inform one of his family members or his friends about the arrest. Now that should be given to all the people. That means like should be treated alike. If any special privilege is given to one person, any other person who is similarly situated, he also would be entitled to the same type of privilege or treatment. So equality before law basically means if there is any type of like consequences or liabilities that a person is facing, it should be same for all the other people who are similarly situated. If there is any sort of privilege or protection given under law, it also should be given to all the people who are similarly situated. So this does not restrict the government to make any special provisions for any special group of persons, right? For example, under IPC, it would be applicable in the whole of India. But even under that, we have exceptions. Children would not come, mentally retarded people would not come. What happens is that equality before law means that the like should be treated alike, not like everyone should be treated alike. And these are the two things that we get under this equality before law and equal protection of law. Is it clear? Article 14, any doubts?
No, ma'am.
Next article that we have is Article 15. It is regarding prohibition of discrimination on grounds of religion, race, caste, sex, and place of birth. So you should remember the grounds that are mentioned. Under Article 15, we have 5 grounds that are mentioned: religion, race, caste, sex, place of birth. And it is talking about prohibition of discrimination on any of these grounds. And this right is given to any citizen. Citizens only this right is given. So what it says is that the state shall not discriminate against any citizen on these 5 grounds. And what happens? No citizen shall on the grounds of, and what happens is that no citizen shall be discriminated on these grounds regarding any disability, liability, restriction, or conditions regarding access to shops, any sort of public places or anything, using any publicly accessible facilities. And what happens is that nothing in this article shall prevent the state from making any provision for women and children. This basically says that state government is or the union government is not restricted from like making any special provisions. They can make special provisions, special laws, special schemes for protection or giving special treatment to women and children. And also it says that nothing in this particular article would prevent the state from making special provision for advancement of any socially, educationally, or economically backward sections. So this particular educationally advancement of socially and educationally backward classes. So under this particular thing, what happens is that state government can make reservation, union government can make reservations under any sort of any regarding education or any other matter, in order to provide enough opportunities to people from the backward classes. Also socially and educationally backward classes of citizens like SCs, STs, there can be like special provisions regarding their admission in educational institutions. For example, there is a provision for reservation of 25% of seats even in private schools. So there was this movie Hindi medium where this provision was like mentioned, that in a private school, like very good private school also, there should be 25% reservation for the economically weaker sections or education for their advancement. So what happens is that they do not need to pay the tuition fee. But the private schools, what they are doing is that they are still charging fees for co-curricular activities, but tuition fees would be waived off under this particular provision. And this is regarding advancement of economically weaker sections of the society, of citizens. So this is the latest amendment that was made, right? That even for general category people, there would be a certain percent of reservation. So what is the percent of reservation? Anyone remembers? For like general category people also, there would be reservation, right? Economically weaker. Anyone remembers? So this like this particular reservation provision, it is also made under this thing only. I think it is like 10% reservation that would be made for people from general category who come under unreserved category. So this is, yeah, it is 10%. So this is the latest amendment that was made regarding reservation. So under Article 15, what you should remember is that you should remember the grounds based on which there should not be any discrimination. And this is in general, not specific to any education or employment or any matter. This is in general, there should be prohibition of discrimination on these 5 grounds. So you should remember the grounds under Article 15. And also this does not prohibit the government from making special provisions or special laws or schemes for betterment of women, children, weaker sections, etc. Now, Article 16 is specifically for equality of opportunity in matters of public employment. So, Article 15 was the general provisions. It may be regarding access to any publicly, like public places like restaurants, parks, using water from wells or any other thing. But Article 16 is specifically for equality of opportunity in matters of public employment. Now, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Now, state would also mean union government, because we saw the definition of Article 12, right? So, state does not mean the states, but it would include state, union territories, union government, or any other like bodies also, registered bodies also. So under fundamental rights, you would see certain rights are available only to citizens. Certain rights are available both to citizens as well as normal persons also. So Article 16, 15, these are available only to citizens. So when you read the article, you would see it would mention the state shall not discriminate against any person. If it is mentioning any person, then it would mean non-citizens also. If it is mentioning the word citizen, then that particular article is applicable only to citizens of India. Only Indian citizens can enjoy this right. So it basically includes 6 grounds: religion, race, caste, sex, descent, place of birth, residence, or any of them. So these are the 6 grounds that are mentioned, and out of these, descent is the only one which is included. Otherwise, rest are like same, those 5 rights only, 5 grounds only that we saw in Article 15. So these are the 6 grounds based on which there shall not be any discrimination in regards to employment or office under the state. Any doubts, anyone?
No, ma'am.
Now what happens, for example, on the ground of place of birth, there cannot be any restriction in regard to employment under state government. For example, there is this Karnataka judiciary exam only. What happens is that it is not like people who are born or, you know, like who studied in Karnataka only they can apply. Anyone can apply. But just in order to ensure that people of this particular state are given some, you know, like opportunities, what they can do is that they can conduct an exam for regional language, so which is done for majority of the states for their judiciary exams, for their like public service commission exams. So what they will do is that they would conduct one exam for local, like regional language. So that what happens is that people from that particular state would get a privilege on this particular part. So that is not like discrimination, right? Anyone can apply, even people who are from other states, they can also apply, but just that they need to qualify that particular thing. So it is it would also come. So these are the 6 grounds that are mentioned under Article 16 of the Constitution. So now what happens is that Parliament has the power that regarding certain employments, it can like mention regarding requirement as a residence within that particular state or union territory. For certain employments, what happens is that it might be necessary that the person has person knows the state, person knows the local language or certain other things, right? For example, one person, he has to work in like remote villages of Karnataka. So it is important that the person knows Kannada. It is important that the person knows the problems that people are facing over here. So for certain employments or so for certain matters, Parliament has the right that it can make it a requirement that residents of the state or territory is like needed. Maybe it may be for a certain months or few months or a few years. And also it is not preventing the state from making any special like treatment for the backward classes of people, and also in matters of promotion once you consider. So like again, regarding reservation and all, state is not, you know, like restricted under this particular thing. So under Article 15, under Article 14, you should remember that it is like 2 things. First is regarding applicability of laws. And second is regarding any sort of privileges treatments which are being given to people. So equality before law and equal protection of law are the two things that are mentioned. For Article 15, 16, you should remember the grounds based on which the state shall not deny. So under Article 14, you would see it mentions the state shall not deny to any person. That means it is applicable to non-citizens also. But under Article 15 and 16, it is mentioned citizen. That means these two rights are specifically applicable to citizens of India only. Only Indian citizens can enjoy this right. So this is why citizenship part is like very important. Part 2. So before mentioning the fundamental rights only, what happens is that Constitution specifically tells us who all are entitled to all these rights. Article 17 is regarding abolition of untouchability. Last three articles are clear, is it? Any doubts, anyone?
No, ma'am.
So next is Article 17. Now what happened is that during the time of independence or before that, what happened is that the practice of untouchability was like very much prevalent, right? So it was also necessary that apart from providing like these two articles, right, for 15 and 16, that there shall not be any discrimination and all, it was also necessary that apart from those things, the practice of untouchability also should be abolished. It's not like sufficient that we are just mentioning two different articles saying that these are the grounds on which we should not discriminate, everyone has access to public places, uh, and all of that. It was also necessary that we have one article that like abolishes this particular practice as a whole. So untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense which is punishable under law. So it was the Protection of Civil Rights Act 1973, which like makes provisions, right, which leads to legal consequences for practice, any sort of practice under this particular thing. Similarly, we have other laws also, like Protection of Civil Rights Act, we have Untouchability of Offences Act, we have of 1955, which was also introduced after Constitution came. Then we have various laws regarding manual scavengers, their protection, their rehabilitation. So after this particular article was inserted, there were multiple other laws that also came in order to ensure that the practice of untouchability is, like abolished, and those people who were discriminated, they also get enough opportunities for their, rehabilitation and then to cope up with the society as a whole. So it is Article 17 that talks about abolition of untouchability. Next article that we have is abolition of titles. Now, what is abolition of titles? Can anyone say what type of titles?
The zamindars kind of thing, the titles which were given before, ma'am.
Yeah. So again, when during the rule, what happens is that during the time when kings were there, they would give certain titles to their political supporters, right? So every year they would give certain titles to those people who are working good on a particular field. Now, after the constitution came, it was essential that we are providing so many rights. We are talking about non-discrimination, no sort of, like untouchability, this, that. So it was essential that all the people are treated equally. There is no sort of, discrimination based on these titles or, like classification or different categories of people. So it was essential that abolition of titles is also mentioned under Constitution. So under Article 18, we have the provision for abolition of titles, and it says no title apart from military or academic distinction shall be conferred by the state. That means all the titles that were there during British time or previously before that, all of those would become invalid. People cannot continue with those titles, and no citizens can accept any title from any foreign state also. And what happens is that no person who is not a citizen of India while he holds any office of profit or trust under the state, except without the consent of president, any title from any foreign state, and no person holding any office of profit under state shall without. So basically, no person is allowed to hold any sort of titles apart from anything that is given because of military distinction or academic excellence, like Bharat Ratna, Padma Shri, Padma Vibhushan. So all of those are allowed. Then doctorate degree, so all of those things are allowed, but apart from that, all the other titles that were existing during the time of British rule, those things were abolished under Article 18 of the of the Constitution. Okay, so first type of right is done. These were the rights, articles 14 to article 18. Any doubts on these articles?
No, ma'am.
Is it clear, everyone?
Yes. Yes, ma'am.
Okay. So see, for like Article 13 also, right? Whatever cases I have given, these cases are basically, like to help you understand the concepts. So what you can do is that you can just go through these cases, what was basically held. It's not like, for example, in this case, okay, if we take this as example, you do not need to remember this particular act which was, like considered as invalid. What was this particular act? You don't need to remember those things. Basically what you need to remember is, for example, this case comes in exam, you should be able to recall that this relates to doctrine of eclipse. So this is what you need to remember. For example, A.K. Gopalan case, you don't need to remember that it was section 14 of Preventive Detention Act only which was like considered as invalid. They would not ask that complicated questions also. But what you should remember is that it was A.K. Gopalan case where this particular principle was applied. Similarly, it goes for this case also, L. Chandra Kumar. You don't need to remember that it was 42nd constitutional amendment which was declared as invalid. It was not like Article 323A, 323B. All those things are not that important. Even if you can remember the case name and what was held in this particular case, it is like most of the times you would be able to answer the question. For example, a question comes that in which case judicial review was considered as a basic structure of the constitution. So 4 options are given. If you can remember that it was L. Chandra Kumar versus Union of India case where it was held, then it would be sufficient for you to answer the question, right? So like this, you should study for these. So are you finding the cases complicated? Like, do we discuss it along with the topics or you want to discuss the cases separately?
Along with it is fine, ma'am.
Yeah, then it is also easier for you to understand the
Yes,
topic
ma'am.
also, no? Yeah. So like that only we would discuss, and it's not like that you need to, remember each and every part of the case, but what is important is what you need to remember. Like this L. Chandra case where judicial review was held, it is Article 13 where you need to remember these 3 concepts. So where you need to remember these 3 concepts: judicial review, severability, and eclipse. So what does this doctrine basically mean? You can also like guess it from the name itself, right? Judicial review. That means what? Judicially will review. What it will review? It will review whatever laws are there. It would review whether it is fulfilling the provisions of Part 3 or not. Doctrine of severability. So if you consider it as a several, okay, doctrine of severability, you can consider that whatever we can make, divide in several parts. If we can divide it in parts, then we would consider those parts as invalid. If we cannot do, entire thing would become invalid. Similarly, doctrine of eclipse. This also is like understood from the name itself, right? That the act would not become invalid, the act would not be like totally dead, but it is only that fundamental rights would cover or overshadow that particular provision for the time being. If there are any changes made, it would again become applicable. So like that, you can just remember the concepts and also the cases. This is the case which explains how one particular provision was considered void and then it again became applicable. This is the case when one particular provision was considered as invalid, rest of the thing was still valid. And this is where judicial review was considered as a basic feature of the constitution. So like that you can remember, not like the entire thing you have to memorize. And similarly for Article 14 also, like for this, first thing you should do is that you should remember that there are 6 different categories of rights and these are the articles. After that, what you should try to remember is what is Article 14? It is equality before law. What is Article 15? It is regarding the prohibition of discrimination on these 5 grounds. So once you remember those things, then you can go to the understanding the concept, right? That there are 2 different things: equality before law, equal protection of law. Similarly, that state can what all things state can do, what all things state cannot do, those things. So like that you can try to remember the concepts. That first of all, it is important that it is part 3 that talks about fundamental rights. It is these articles which are providing for the rights, and then you can go to the section wise. And it is only like part 3 and 4 where you need to all the articles are important. It's not the same for the remaining parts of constitution also. Okay. So till here it is clear, right? Anyone, any questions?
Yes, ma'am.
Fine then. So the first type of right we have discussed today, the right to equality. So next time we would continue with the right to freedom, and also right against exploitation. So we would also try to look at some of the statutes which were which came after the Constitution of India, right? Based on those particular articles which we have, what all statutes came and what all things are applicable, those also we can see. Okay, so fine then. I will end the meeting here then. Thank you.
Okay, ma'am. Thank
Thank
you.
you, ma'am.
Thank you.